So what the Supreme Court has said is, there should be a level in between these two, between the police acting on the ground and the sort of the government. There should be an autonomous body, call it State Police Commission, which should comprise of not only the Chief Minister, but the leader of the opposition, a judiciary member, either retired or whoever it is, plus some outside experts. There should be a body to whom police should directly report as far as their working is concerned. The police is the sort of most visible arm of the government. If I go somewhere, people may not recognize me as representing the government. But if a police constable goes, they know that he is an extension. He is a visible face of the government. And he is also the coercive arm of the government. I'm saying this because coercive arm means what? It is the only force in the government which by law is authorized to use force to enforce law, to enforce the rule of law. And how much force? And that depends on the situation. So to the extent that they can deprive you of your civil liberties, your freedom, they can arrest you for certain cases and then detain you, question you, and all these things. So it is in a way, it is a coercive arm of the government. Now, I'm using the word government because I will come back to that. So under what law do we operate the police? Before that, as I said, they are the enforcers of the law, I said, the rule of law. Now, in India, what happens is our legislatures keep on enacting laws. How many, every parliament session, you see more laws are being made. Pick up any law and you would find there would be a section called offenses. If it is a Dowry Prevention Act or Child Marriage Act or Wildlife Act or any damn thing, Environmental Protection Act, there need not be crime only. You take any of these laws, in that there would be a provision saying offenses. And then there would be another clause saying prosecution. Now it says, if anyone has committed a violation of that particular law, as I said, it could be Wildlife Preservation Law, it could be Forest Conservation Act or anything. It says the police can investigate the case. So any law which is made in India, the investigation is with the police. Not with me, not with... There are very, very, very few exemptions where, a Tahsildar or somebody can investigate. But by and large, 99.9% of the cases, the investigation is with the police. The first question I want to ask you is it necessary that in relation to social legislations, is it necessary that the police have to be brought in? And if the man has to in addition to these, the criminal laws are there, called the Indian Penal Code, the Indian Evidence Act, and the procedure, the Criminal Procedure Code and all that. These are a subject by themselves, and all the lawyers would study for 3-4 years, Now, if somebody has to implement these laws, enforce these laws properly, that man, whether he's a police constable or a sub-inspector, has to be a superhuman being. He must be one of the most knowledgeable persons on earth. He should know all the laws, what are the implications of those laws, when he can arrest, when he cannot arrest. And then, the subtleties of the law and all that. One law I would tell you is relating to the criminal law. What is it called? It's called defamation law. The defamation law says 499 section. These are all relevant, If somebody defames the other person, you can file a criminal case against him. Do you know the law runs into, there is a main clause, then there are 4 exceptions, 4 explanations, and then there are 10 exemptions which are provided in that particular section. Now, how do you understand these things? Just an example I am giving you. So they are supposed to enforce the laws. Now, what is the authority under which the police act? Till very recently, the act controlling most of the police in the country is what is called 1861 Indian Police Act. The Indian Police Act is of 1861. And before that, there was another law, because the first capital of the British was in, not capital in that way, settlement was in Madras. The Madras passed an act, it is also called the Indian Police Act, 1859, so 2 years before this. Then the main act came in 1861. What is the reason why that law came in 1861? Because 1857, as we all know, the so-called First War of Independence of India, the Sipahi Revolt or whatever it is called, that took place in 1857, which shook the foundations of the British Empire. Then they said, no, we must have a law. The police force has to be there. They have to be under a law. That's how 1859 and 1861, these laws were made. Now, till very recently, that is around 2010 or so, this is a law which has been adopted by every state, and they were working under that. And what is the purpose of this law? The purpose of this law is the police have to maintain law and order, see that there are no demonstrations and other things against the government. The government is properly protected, government property is properly protected, and communal harmony is maintained. If there is communal clashes between the groups, whether it is a labor and management, whether it is students and authorities, whether it is Hindu and between communities, all this maintenance of the law and order is their main function. And the law did not say how they should exercise, and tremendous powers were there. The law did not say how they should exercise these powers. Whatever is the means, you can follow any means. They have not been defined, but you must maintain the law and order. And investigation of crime and prevention of crime, they were also there, but the emphasis is not so much on that. The emphasis is more on maintaining the law and order. Now, and this law was made for a colonial government, and it continued all this time. And all this time, in the sense, let me give an example. The Andhra Pradesh, the present Andhra Pradesh, which were earlier also combined together, do you know the law under which they operate even today? It is called the Police Act 1859. As I told you, even before the Indian Police Act was made, there was a law made in 59 for Madras Presidency and all that. So we are still following that. Then you might question me, no, haven't they done anything? They have done something in 1989. It's called the Andhra Pradesh Police Act of 1989. It has only 4 sections. It only says that this applies to Andhra area. This law of 1859 would apply to Andhra area. That's what it says. Then there is another law made in 2004. That's called the AP Police Reforms Act of 2014. That has got only 4 sections, not even 4, 3 sections. It says how the DGP has to be selected. I will come to that in a minute. Except this, the basic law is of 1859. So what has happened is people have been thinking about it, and we should have a police force which has the democratic ethos, which serves a democratic government, and they should take care of the the exploited sections of the society, provide law and order, provide succor to these people, and all these things. That's how the thinking has come. I am a great sympathizer of the police working. They work under very, very difficult conditions. And second thing, I must say that police reform was driven by a number of police officers themselves. They felt the need that there should be a reform in the police. And so what has happened is, when the reform was 1979 to 1981, 3 years, the first police commission, the National Police Commission, worked, and some volumes of report they have submitted, and they said the law should be changed, and it should be a law which is which follows the ethos of a democratic society and all that. Not only that, then in 1980 itself, they formulated a model police act, saying that this police act should be implemented. And thereafter, since it was not being done, One of the police officers went to the Supreme Court. The decision was given in 2006. Prakash Singh. He said, we have been talking about police reforms. There are reports here and nothing is being done by the governments. So no government touched these things, irrespective of the color, whether it is Congress, whether it is BJP, whether there was a communist part also in the this one, coalition governments, no government wanted to touch the police reforms. But the police officers themselves were wanting it. And a lot of intellectuals said that this police must be reformed. And so in 2006, the Supreme Court passed a number of orders. It's called 7 directives of the Supreme Court. What are these directives? And what is the basis for these directives? Now I must tell you another aspect. There is a basic approach. As I told you, the police have 2 sets of actions to be taken. One is prevention of crime. And if the crime happens, detection of the crime and investigation. This is one part. The second part is maintenance of law and order in the society. That means public demonstrations, agitations, the whole lot of it. Political, social, agitations and all that. The first part is who is the boss for the police? That who should supervise the action, whether he is prosecuting properly, whether he is making a proper case or not. It is the law. Law as enshrined in the Indian Penal Code, Criminal Procedure Code, Evidence Act, and in the Constitution of India itself. The government of the day should not have any say in that. What happened is, but the other part is very much the responsibility of the police, the reporting, the authority, the control of the police has to be with the government of the day. Why? Because it is a question of maintaining the public law and order. Demonstrations are taking place, major agitations are taking place, trains are being stopped, roads are being closed, etc. Now, how do you reconcile these 2 functions? One is a law and order function, The other is crime investigation, detection, and punishment, prosecution. Now, these 2 are totally different ones. But government has no authority, should have no authority, the government of the day, on the second part, the criminal investigation, while they can continue with the first part, that is maintenance of law and order. Now, this becomes extremely difficult. So what the Supreme Court has said is, there should be a level in between these 2, between the police acting on the ground and the the government. There should be an autonomous body, call it State Police Commission, which should comprise of not only the Chief Minister, but the leader of the opposition, a judiciary member, either retired or whoever it is, plus some, outside experts. There should be a body to whom police should directly report as far as their working is concerned. So, constitution of a State Police Commission is one of the most important things, and their responsibilities to completely oversee the working see the working of the police forces. The second one is, since the police is a part of the government in a way, the transfers and postings and everything are done by the government of the day. There was a case, it used to happen till very recently in UP. Political leadership has taken the authority to transfer the station house officer, what we call the sub-inspector, They used to transfer as the like. Ultimately, order might have been issued by the Superintendent of Police, but under the direction, control of the Home Minister or the Chief Minister and all that. And so, now, arbitrary transfers. Now, you don't give time for them to do that. And then they dictate what section should be applied when a crime is being committed, who should be arrested, whether it should be a bailable case or a non-bailable case, whether bail should be asked or should not be asked. All these things are being to an extent.